What every Social Security disability applicant needs to know about drug abuse or alcohol use and mental impairment. Now, Social Security will deny a claim if a person's medical records document that their drug or alcohol use or abuse causes or contributes to a medical determinable impairment. And that's particularly true both from a physical standpoint, but also from a psychological standpoint. I'll be frank, Social Security has admitted that they don't know of any research or data that would predict reliably whether a co-occurring mental disorder could improve to the extent that if you were to stop using drugs or alcohol, that mental impairment would or would not be disabling. And this is a chicken and egg analysis. In other words, there are people who have psychological issues who use as part of their psychological problem drugs or alcohol. They'll self-medicate. On the other hand, there are people who also become addicted to alcohol or drugs because of their physical problems and then go on to develop psychiatric problems. And then there are people who have psychiatric problems who use and abuse concurrently. In other words, one's not influencing the others. So this is difficult, I think, for the Social Security Administration to sort out. In the case of a mental impairment, they're going to be looking at the medical evidence in your file to first establish, one, what the nature of the mental disorder is. Number two, is there a concurring mental disorder that would not be disabling in the absence of drug or alcohol use? And then there, of course, is the question of whether this is just pure use and abuse of alcohol or drugs. So they're going to go through this analysis looking at your medical records. And generally, Social Security will say that the drug and alcohol abuse, DAA, is not material so long as the evidence doesn't establish that your co-occurring mental disorder would improve to the point of non-disability in the absence of DAA. In other words, you might have bipolar disorder, which in and of itself could be disabling, even without the use of alcohol or drugs. Or your bipolar disorder could improve to the point of non-disability if you stopped using drugs or alcohol. So the analysis really goes to how the alcohol or drug impacts your underlying psychiatric issues. If the severity of your psychiatric issues is such that you would be disabled in and of itself, regardless of the drug or alcohol use, then that drug or alcohol use isn't material to the determination of your disability. On the other hand, if the severity of your psychiatric issues is such that you would be disabled by or in combination with the drug or alcohol use, your claim will probably be denied. And then finally, if your psychiatric condition would improve to the point of non-disability if you stop using drugs or alcohol, then definitely your claim is going to be denied. These cases clearly are difficult to win, and we at Cavey Law don't generally take these cases but just because of the complexity. Now, that doesn't mean that you're not entitled to your Social Security disability benefits, but we may not be the firm to represent you. I do want to leave you with this knowledge, but I want you to understand that drug or alcohol abuse can really result in a situation where the claim gets denied, where otherwise it might be payable. So if you have any questions, please reach out to NOSCAR, the National Organization of Social Security Claims Reps. They can help you find a Social Security disability attorney who will specialize in the issue of Social Security disability claims with mental impairment and drug or alcohol use. Thanks.